Okay. Notice to admit facts is a very handy procedure. Notice to admit facts exists in the New South Wales under Section 17 of the Uniform Civil Procedure Rules. In Queensland, you have notice to admit facts. In Victoria, they have notice to admit facts. In America, they have the process. In the UK, they have the process called notice to admit facts and admit authenticity of documents. The courts encourage parties to settle their differences and their disputes before coming to court and not worry the courts about details that don't matter. The court likes you to refine your case down to what is really in contention, where the issue is going to be about some particular point of law or some fact or piece of evidence or something like that, about which there may be dispute. So they want to refine it down to what is really an issue to save time, the court's time, and not bring in a lot of fluff and other stuff that doesn't matter. So notice to admit facts is a procedure where that can be done, where you can whittle down your case to just what is in issue to save time, costs and worry and so on. Notice to admit facts is a process whereby people can work out their issues before coming to court, and Section 17.3 is the particular section that has to do with the notice to admit facts, and Section 17 is the section which is a judgment on notice to admit facts, judgment on admissions. Now normally what you're familiar with when going to court is you may retain a solicitor, you may put on your evidence, put on your arguments, put on your statement of claim and go to court and argue by presenting your evidence and arguments verbally and seek a decision based on the balance of probabilities. In the criminal division, it's beyond reasonable doubt, but in the civil division, it's about 50%. Criminal division, it's about 90%, 95% certainty, but in civil, it's easier to win because it's about 50% on the balance of probabilities. So you seek to put on your material normally and do all of that and prove it on the balance of probabilities by putting on evidence. The other way is just get the other side to admit everything and it's all over Red Rover. Now that's not something the lawyers make a great deal of money out of because they don't get performance fees. But it is a process that it is allowable under Section 17 that at the commencement you start with the jurisdiction of Section 17, or what section is it in Queensland?
It's still 17.
No, it's number 100 and something.
Yeah,
175, 100.
I did send it out.
You sent it to me, 169 or something. There is a section, virtually the wording is pretty well the same, and so you do that, and the beauty of it is that if they ignore that, it's a minor contempt of court, and they're ignoring legal process, and the section says if they do not answer within 14 days, or they do not respond to it, it's admitted in your favour. So it depends on how you write each request to the notice to admit facts, and you may start it off by saying, do you admit or agree that it is, write this down, this is important, do you admit or agree that it is the case, do you admit or agree that it is the case, comma, is it not?
David, do you want to bring it up on the TV?
Yeah, you can be bringing some of these things up,
Yeah.
so we can
So
show
you might want to
some
do
documents.
Okay.
Do you admit or agree that it is the case, comma, is it not, comma, that as claimed, comma, the following facts is or are so. Following, and that's the preface for each of the requests to admit facts, and you lay out your points, each one per paragraph for each request to admit facts. You lay them out in detail. Each paragraph has to be one sentence. You don't split up a request to admit facts into multiple sentences because it's got to end with a question mark. So the request to admit facts is going to be ending with a question mark. It can be a lengthy sentence in which you seek to lay out your arguments, your compelling arguments, even refer to evidence, etc. in each request to admit facts, because if they don't answer or respond, within 14 days, that point, for the purposes of the proceedings, is admitted in favour of the requesting party. And I've got one here that we're going to show you today, which is an example of that, which wasn't responded to in the 14 days, and all resolved by law in favour of me as the requesting party, entitling me to a judgment on admissions under section 17.7, and you would have a similar section in Queensland, judgment on admissions, because it's all admitted under the law. A good step then is after the 14 days, you then resend to them a copy of their section 17.3 or whatever section number it is in Queensland. You send, that's the Ritchie's rule. We need we'll come back to that in a moment. We'll come back to that.
The right one?
That's Ritchie's rules on precedence in notice to admit facts. We need the one,
Notice to admit facts.
not EFP, Westpac notice to admit facts,
Oh,
where Westpac admitted everything in the major case. So that was done on Westpac. Go down a bit. When you do your notice to admit facts, you take the form off the website for the courts, and the good idea is to, go down a little bit further, is to copy into it the actual legislation, the section 17.3 or whatever it is, put it actually in there so they're on notice, so everybody knows what the rules are. So you put in the rules from the Uniform Civil Procedure rules, put them in there, then go down a bit, and then you start asking away. The plaintiff requires to admit the following facts. Do you admit or agree that it is the case, is it not? But as claimed, the following facts are so, blah, 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 blah. And I did about 30 of them in that particular one, and they weren't answered within 14 days. So the parent guarantor has admitted everything under section 17.3, entitled me to a section 17.7 judgment on admissions in a case that's never going to go back to court, because my matter does not go back to court because it was in court once and it doesn't go back to court unless the debtors are being sued by a creditor, and then I can say my 2 cents worth.
What was the question again? Do you admit or agree?
Here it is. Do you admit or agree that it is the case, is it not, that as claimed the following facts are so? Blah, 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 blah. All in one sentence. I suppose you've got to be pretty good with words to be able to write it all in one sentence and know your arguments and your case very well, and you should know your case, because the court presumes you know your case, just like the court presumes you know the law. So you've got to lay it out to make a compelling point or two in each paragraph and win each one of them to the satisfaction of the court, should this ever be disputed. After each one of them, you put in 1B. If you do not admit or agree, then why do you not admit or agree? So you ask them that if they don't admit or agree. C, if you say the facts are not so, then why are they not so? D, if you say the facts are not so, then how are they not so? This ties their heads in a knot, this doesn't. E, who told you this and what is their experience? So they look at all that and say, oh, we're not going to answer this. We won't answer it. Go up a bit. So it all gets too much work, because they don't want to go up a bit further.
Can we get a copy of this?
Yeah, we can send you a copy of this if you like. This will give you a good understanding of the whole case, because Westpac admitted everything, because I laid everything out in tremendous detail. You can put a lot of detail in your notice to admit facts.
I think this has already been sent out.
No, this one hasn't been sent.
No,
They
we
haven't
haven't.
received this one yet.
Yep.
So they look at section 3. The admitting party may, with the leave of the court, withdraw any such admission. So they look at section 3 and say, we'll resort to that, we won't answer anything. So they admitted everything, and under the High Court rules, the only way out of the section 17.3 is if your lawyer is 1 day late. On the 15th day is the grace day, and they can get out of it, the lawyer's 15 days late. And Ritchie's rules covers that in New South Wales. You would have an equivalent to Ritchie's rules, the precedents, the case law of the Uniform Civil Procedure rules, and you can look that up and see what the precedents are. So I think you'll find there's no way out of it.
So you're saying that point 3 in regards to the leave of the court is dependent upon them actually filing a submission for its withdrawal within 15 days. Is that,
Well, you can tell them later on at some point, if they want to wiggle out of section 17.3, they go back and initiate the case in the court to get out of it. They become the initiating party to file, and you don't have to pay the filing fees. So, they may with the leave of the court, but they don't get it just for the asking. They've got to give darn good rules as to why they didn't answer all of these questions. Especially when you do the next step, because after you've done the notice to admit facts and the 14 days have passed, then you give it about another day or two, and then you write to them again, and you write notice of your admissions under section 17.3 of such and such date, 14 days after you serve them, and you write down their admissions, admitted, and give them another 14 days for confirmation. So this is the second step. When you do that, and you ask them that, and you put in, after each one, in bold, admitted, then you can elaborate on it and go into further detail, and go further detail again that's occurred to you in the meantime, to elaborate on each of the points and do more, and give them another 14 days to confirm it and see what they do. I've never seen anyone answer that one yet. They haven't got an out of that. And then after that, you can write to them again after they've admitted and confirmed everything under the appropriate section of the Uniform Civil Procedure Rules. Then you then invite them to exercise their section 17.3 rights to seek the leave of the court to withdraw the admission, and you give them 28 days to do that. And they've got to initiate an action all in the court. And if they don't approach the court to have their admissions and confirmations set aside, they've got to have good reasons for each one of them, then they've abandoned their section 17.3 rights. So, any questions on that?
Just to confirm, that's only for matters over $10,000?
$10,000 in New South Wales, maybe the same in Queensland, but over 10,000. So you can't use it in small claims in New South Wales. You may not be able to use it in small claims in Queensland, but you can try. Sort of lays out all the arguments and refer to it as explanatory as assistance to the court to lay out all the arguments, even though their admissions can't be relied upon in the court. It is a useful document if well done. So notice to admit facts can explain your whole case, lock in arguments, and do it effectively if over $10,000 in New South Wales and probably in Queensland. It's a good step to do because it will really clarify your case in your mind as you write it out. Yes?
Is that similar to the writ they send for repossession?
No.
No, because that's
Not a
sort
writ.
of a similar thing you have to answer.
This is, notice to admit facts is different to a writ as you have to answer. There are parallels to this. This is in the civil courts, local, district, supreme. The federal court has a parallel section, I think it's section 2001 or something. So the federal court has this procedure. The family court has this procedure where you can use it in family proceedings as well too. You'll have to look it up, but you'll find they're all similar. And you may be able to use it in the other areas as well too. Maybe a tribunal will look at it as well too. It can be a handy document. If the court says it's below 10,000, you can point out it may not be of effect, but it is a useful guide to explain my case and ask what questions I seek to have answered if the court gives leave or the tribunal gives leave that these questions should be answered for the clarification of the court or the tribunal. One of the secrets of doing your case is do it all in writing. Don't get into verbal presentations. I don't like to get into verbal presentations in court. I'm not trained for that. Barristers and solicitors are. They can tie you up in knots. So I prefer to do it all in writing. So just hand it up. If you come to one of my hearings in court, you won't see much of a performance. You just say I seek leave to hand up my submissions.
Let the documents do the talking.
Let the documents do the talking. It's all written in there. You don't have to remember anything. You've got plenty of time to prepare your documents and put them and just hand them up. And then ask the court to look at them 14 days. Then might be short, so they can look at them quickly. give it to the other side, although they've already got a copy of it because you've served it on them, so they know it's coming, and they've had plenty of time. Yes, any other questions? Okay,
And that process be used for anything else other than money?
yes. Can't use it in criminal because they're not obliged to answer in criminal to incriminate themselves, but it's in civil. You can try it in criminal. Who knows? You don't know what the use they're going to make out of it. You can try. When you do, you're declaring yourself. You've got to declare yourself at some point what your argument's going to be. Not leave everything. You want to go in there for the jugular if you know you're ultimately right. And you should only run a case when you know you're ultimately in the right. You're going to win. If you're not, you should apologise and seek to get out of it.
That's the advantage I found by self-presenting, is you don't have to hand over your arguments. If you can employ a brief, he's obliged to hand over the arguments. You catch him by surprise on the day.
But you don't want to catch them by surprise because you might find they're saying you've caught us by surprise. So we want 14 days to study this, but you can still hand them up.
Yeah.
But they better be good. You've got to know what you're doing when you're a litigant in person, when you're going to court. You've got to know what you're doing. The court appreciates it when you know what you're doing, and it saves the court's time, etc. And you want the other side to understand the case, because if everyone all floundering, the case is a mess and it's no fun. But you want everyone to understand the other side, to be brief and know exactly where you're going if you're ultimately the one who's in the right. Otherwise, if you're not ultimately in the right, you shouldn't be there. The court presumes you know the law. The court presumes you know your facts. The court presumes, therefore, you know if you're going to win or lose. So that's why you get hit with costs if you lose, because you're presumed to know that you were going to lose, because you're presumed to know the law by the court. Okay. Any other questions on notice to admit facts? Or we'll move on to another process. Has that been useful?
Yes.
Okay. So learn to master notice to admit facts. Learn to use it and use it well.
Just before you do move on, you said limited to $10,000 or more. Is that documented in the preceding material, I suppose, within the UCPR? Does it have to be documented there somewhere?
It's in the practice notes in the courts in New South Wales. It may be in the practice notes. I don't know if you'll find it in the UCPR, but it's within the practice notes in New South Wales. It's not used in small claims.
Okay.
And I tried once and they just put it aside and said, you can't use that here in small claims. So, well, yes?
It's notice to admit fact and authenticity.
And authenticity of documents, yes. Because you can submit documents, you can email your documents, and I like to do these by email because I like everything in the computer and everything. I don't want papers all over the place. I've been to litigants in persons places and they've got papers all over the place. Maybe you've got papers all over the place. It's best to have it all in the computer and be organised so everything's at your fingertips rather than papers all over the place. So you want it on the computer.
Have two computers, one online, one offline, because they send red ones in after you.
Yeah, we've got Microsoft, yes. So I've got Linux. I had the Amiga and I had Linux. Got off on the right foot. Move on to the contractual civil debt. We've talked about the contractual civil debt. We have the precedent for it now in my matter in the Supreme Court in equity where somebody lost, which means it was in existence, which meant somebody won. Because in a contractual civil debt, there's a winner and a loser. As you may be aware, courts generally don't concern themselves with bets and wages because they're not contract. They don't have the elements of contract. They're chance, improbability, uncertainty, not the elements of contract. Whereas a contractual civil debt is not based on chance, uncertainty and improbability, but on evidence, arguments, admissions and so on. and you are presumed to know the law, and you're presumed to know your facts, so you're presumed to know whether you're going to win or lose. So it's not uncertainty or improbability and chance, because you're presumed to know. And you should know your case, and you shouldn't do it unless you're going to win it. So you do a contractual civil bet for an amount of money, and you should have that amount of money somewhere in reserve. Because an ante, if you were going gambling, you've got to put up an ante at the poker table and actually have the goods to back up your bets, etc. So you may get an argument that you didn't have financial capacity to do it. Fortunately, with Reserve 1 I did in that contractual civil bet. So, but there's the element of mental capacity and there's the element of financial capacity. So you lay your contractual civil bet and you ask for their response. What are they going to do? Pay it or argue along or whatever. Now you lay your bet and you tell them after 14 days this will be in force if you do not withdraw or present your arguments or whatever you're going to do. You give them 14 days or the bet is on. I gave them, well, they took it up in the case of the one with the state of New South Wales on the evening of Friday the 14th of March by seeking to win it in one fell swoop, very decisively, a very decisive chance effect to win, which I saw that they didn't. I realised what was happening on the Friday and they didn't win that, but I had my evidence that it had been accepted because they committed an act of acceptance of a contractual civil bet on the 14th of March. So it was on. And eventually I won on the 24th of February 2016, about a year and a half later. So other questions about contractual civil bets. It's a dispute for consideration is another term for it. You can have a dispute for consideration, a contention for cash, if you would like to call it that. A contractual civil bet, which is contract, not chance, on evidence, admissions, argument, and submissions that you're going to put, and you settle it in the court. And you should know you're going to win 100%. It's the only form of betting that I do, contractual civil bets, when the opportunity arises. You've got to be perhaps fairly legally savvy to pick up when one of these opportunities comes along. But they can come along from time to time if you're intellectually, legally savvy and you pick up that one is happening. So if you know how to play it, you can come into an interesting win on a contractual civil bet. Yes?
I know it's only small scale, but it's only small scale. Origin put a black credit mark on my credit rating,
Yes.
and I ended up in court with them to remove it.
Yes.
So I only got a small piece of compensation because it was only a small electricity bill, really. It was about that. But you could apply it to something like that if it was over $10,000.
Contractual civil bet can be done at any amount for which you've
As
got
long
the
as you know
financial
you're
backing
gonna
to do it. As long as you know you're going to win.
Yes, of course I
You
know
don't
I
do
can't
it if
win.
there's an element of risk, chance or uncertainty,
Right.
because the court doesn't support those.
I should have done it.
What you would do in that case is correspondence. And cases should be run first of all by correspondence, first of all, before you file. Correspondence or notice to admit facts, so you do correspondence.
Yes, I did that and they refused.
If there's a black mark, you write to them, and you do some correspondence first of all.
Yes, they haven't laid out the law and they still refused, but
You may have been at fault.
I won anyway.
You may have been at fault for not paying your electricity bill.
no, I won.
You won, okay.
Yes.
Okay. Any other questions on contractual civil bets? It's a very useful forensic tool for the court to watch two parties where there's a contractual civil bet in play between the two parties. It helps the court understand the case and deliver the win. So it's a very good forensic tool.
Except when the justice is getting part of the bet and making the decision.
Well, yes, that can happen, as happened in that matter in equity.
So you need to make sure that they're not party, they're not...
Well, you need to make them the offer first. Look, I'll give you half.
And so there's a judgment against you in which the justice came into some money.
Yeah.
totally undermines the judgment. The judgment is set aside.
But isn't that what happened in your case?
The judgment was, but the finding that there was a civil bet in play stands.
I was under the impression after talking to you before that the justice was going to be one of the recipients. He was one of the
Yes,
eight.
one of the 8, yes.
So isn't that...
He wrote the winning ticket, so he was one of the
So
8.
how can you be a judgment in your own matter? How can you be a judge in your own matter? Which is what effectively that was. He was going to win out of that.
In that case, it was based on another argument, something else. And I lost on that, but I got the precedent of a contractual civil bet having been in force, which is really what I wanted, because it was all about money and not what they were thinking it was about. So the judge wrote a decision, and he became therefore, ipso facto, he became a winner, and so did the witness. The witness also received a large amount of money. Of course, that sets aside the whole case, so the judgment doesn't matter anymore.
Isn't that unconscionable conduct of a judge?
I don't think any of us saw it coming, and the judge seemed surprised that that had happened. We were all surprised, but we didn't know that can happen with a contractual civil bet. So it's an interesting answer. I don't think it was corruption. I just think we didn't see it coming. It was a lesson to be learned. As the judge said, you're always learning new things about the law. And so...
Well, that's a nice handy little answer.
That's right. I didn't know.
so
I
that
didn't know I
decision-
was just going to get a few $100 million out of this bet.
Yeah, you didn't know it was going to be $250 million, 1/8 of $2 billion comes his way, which of course he can't take advantage of, nor could the witness. So the $500 million slides back to me, and I have a win of $500 million, which means I win on the area of capacity as well, because out of the case I've just made at least $500 million, and they're only on wages. So who's got the mental illness now? Not me. I just want to
Maybe you have because you have
congratulate
delusions of grandeur.
Pardon?
Maybe you do because you have delusions of grandeur.
Oh, I got the evidence. I got the evidence. And then the admissions too. I got the admissions. They've admitted everything. So winning all around. Any other questions on contractual civil bets? Okay, we'll move on to the determinable, evaluative, presumptive, general, equitable lien. We've heard of liens. Maybe you didn't know that there were two sorts, the equitable lien and the common law possessory lien. So there are two sorts. We're not talking about the common law possessive lien. We're talking about the general equitable lien with a couple of qualifications on it, that it is a determinable, evaluative, general equitable lien. It's one of the best ways of getting a debt paid, at least anyway, if you do one of these on somebody who hasn't paid their debts to your business. You do a determinable, evaluative, general, presumptive, general equitable lien. Now let's suppose you have somebody who owes you some money. You've got a business and you've got a debtor, and the debtor owes you, say, $5,000. And you've written them the letter of demand, you've written the letter, done some correspondence, they're not answering, they're not paying. You know they've got some money somewhere, or they've got some people who owe them some money that they can refer on to you, and you can get their bad debts and chase them up with general equitable liens to the second level and do creative debt recovery by going to your debtors and doing things like that. But the general equitable lien has a couple of qualifications. It's determinable. Now, if you know a bit about liens, how long do they last?
99 years.
99 years.
Unless you put them into a trust, and it's forever.
Yeah, then forever. This one that lasts 2 weeks. You may not have heard about a lien that lasts 2 weeks. It's only an intermediate stage because it's determinable. You can determine the lien. You can bring it to an end after 2 weeks. It's just an interim stage. So it's determinable in that it has a life of 2 weeks before you determine the lien. Like you can determine a lease, you can determine a lien. You're the one who created the lien, so you tell them, I write to you in relation to an amount outstanding of $5,000 to which I seek payment. Thus far you have not paid, so I now advise that I am now going to take a determinable, evaluative, presumptive, general equitable lien over your assets if you do not pay me the amount of $5,000. It's evaluative in that it evaluates their assets to the amount of the debt. So the lien is evaluative that if they don't pay, then their assets must be worth about $5,000 or less, or otherwise, if they're a reasonable person, they pay the debt, if it's a real debt. It's presumptive, it presumes they don't really own anything, and it presumes their assets down to virtually nothing if they don't pay the debt, so it's presumptive. So it's a life of 2 weeks, and you say if after 2 weeks you have not paid, I shall determine the lien and then become the owner of those assets, if any, whatever, wherever they may be, anywhere in the world, because it can be worldwide, it's a worldwide process. So I should start, the first step is you ask them for the $5,000 and then say after 14 days I will take a determinable, evaluable, general equitable lien over your assets if you do not pay within 14 days. If they don't answer within 14 days, you then send them the letter by email or by post. If you do it by email, maybe you better follow up with a phone call and say, I shall now take the lien for an additional 14 days, and this lien will be determined after 14 days, and then I shall determine the lien and become the owner of your assets in lieu of the debt, which are presumed to be less than $5,000, otherwise you would pay me. If you do not pay me, it's presumed you don't have any assets at all, and you forfeit those assets and I become the owner of those assets. So it requires a bit of writing of letters to be done, to do these steps, and this is all in preparation should the matter go to court, because all this has got to be tested in the court yet. These steps haven't really been tested in the courts, so we want to test these steps in the courts and see how we go. But it really gets a risk jump out of them when they start getting these sorts of letters where they've got a evaluative, presumptive lien against a debt that they don't want to pay. And you can say, if you don't have the money, but you have people who owe you money, I'm happy to accept those and pursue those debtors to recover the money owing to me, or going to your debtors, if you would like to make those as payment, if you're prepared to accept that.
So you can take them for all of their assets even though it's worth more than $5,000?
Well, they're evaluating their assets down to $5,000 by not paying you unless they respond in some way.
What he's suggesting is, if it's say for $5,000 and they're not paying it, then they're saying that they haven't got the assets, they haven't got the equity to actually give you that $5,000.
Which means if they've got property, they're abandoning it, and you might as well pick it up. Yeah, because they're abandoning their property, their business, or whatever it is, so you can pick it up and sell it, or do what you like, become the owner. So sometimes it's better that they don't pay you, because you can pick up, who knows what you're going to pick up, what you can find if you do land title searches, or what there might be, because they're abandoning it. And then you say, so after an additional 14 days, I shall determine the lien and become the owner of those assets, and should there be property, real estate, I shall then start commencing rent, charging rent at the rate of $1,000 a week residential, $1,000 a week residential, and $3,000 a week commercial on tenants or upon yourself as the owner of those properties, and that shall accrue until it takes time till I actually take physical possession. So it'll get your debts paid, rather than a letter of demand where we say we're going to take legal action and take you to court. We might laugh at that. But anyway, so here they can be surrendering their assets. There is an element that helps with a general equitable lien, and that's the element of outrage or unconscionability. Like if they haven't done anything really wrong or something, then your argument is not as strong as if they've really been out to scam you. A general equitable lien is really good against a crook. If some crook has really been out to scam you, you take a lien over all their assets, because the element of unconscionability and outrage is there. And that can be on a sliding scale.
So how do you realise, or how do you enforce that lien. So after the 14 days or after the 28 days, how do you sort of realise it? How do you...
Well, you've got to find out what they own too.
Yeah.
You may get them in for examination at some point. So that's a process we've got to experiment with in the courts, to seek to do examination where you examine them, or you do searches on land titles to see if they own any property anywhere. Find out what they own. You've got to find out. They may not have anything anyway.
I remember I had a small claims court with a shop, and they were required, if they didn't pay the ordered cost by the small claims tribunal, then they would have been required to appear and bring their books for an oral examination, what they called an oral examination. They had to justify why they couldn't pay the debt. So I assume you'd be doing a similar sort of...
You could do that process. You may need a good barrister to do something like that, if you're no expert in that. And I don't think the average person is an expert in that sort of examination. You won't know. A good barrister may know how to get them to admit things and so on. Because if they deny it in the witness box under evidence, they're abandoning it anyway. It becomes yours to pick up. Because they're abandoning it in court or tribunal. Yes?
I've got that problem at the moment. We won our case with the bank. The first solicitor we hired, he's now been found guilty, lost his licence on our case, and he put a lien on us because now we're in court.
A lien or a caveat?
No, he definitely has said that your property is now under a lien and wrote me an email on that.
It's interesting to know what sort of lien. Would have to be a general equitable lien.
Well, I'm not too sure what it is at
You
this
can ask me,
stage.
don't you mean a caveat? Because they usually do caveats.
Yeah, well, so he's now suing us for his 4 months of work that he's now been prosecuted and lost his licence on, so.
So he really wants to get it off you because you caused him to lose his
Oh,
licence.
he is
He might
really
go for
angry at
damages.
me. He is. Well, it wasn't me he just sent a $50,000 bill. I went to the Legal Services Commissioner. They decided to open a case and prosecute him, not me. That prosecution, as I've said to him, has nothing to do with me. I just provided...
And you lost the case?
He lost. He took him to the Supreme Court. He lost. It couldn't stop them from prosecuting him, and then they took his licence for 3 years, and he has to complete lots of different stuff over the next 3 years to get his licence back. So, yeah, it's very interesting. So I'll send that over to you, so I'll know.
Yes, send it over.
Do you
Yes.
have a template of notes for this process?
Well, it'll be on the audio, on the video, what I've said. Template.
Just a bit quick to try and write down.
Re-listen to it.
Yeah.
Re-watch it, re-listen to it.
Yeah.
With the whole family watching on and so on. So they can all talk about it and the children get educated and so on. I'm an ex-teacher, so I like to educate. I have a class, and that's my email, isn't it? I have a class. Don't keep people in isolation. Privacy laws keep people in isolation, as I've noticed. Any other questions on general equitable liens? No. We're going to